at 5 p.m. They need to feel worthy.
This is the TAN Talk Radio Network.
It's time for FLA Law, brought to you by the personal injury attorneys of Perinick, Caulfield, Averill, and Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
Good evening. We are back here live, and these are your hosts from the attorneys at Perinick, Caulfield, Averill, and Noyes for FLA Law. As I said, we are the injury attorneys at the firm of Perinick, Caulfield, Averill, and Noyes, and tonight we're going to do another call-in session for your legal questions. If you were able to tune in last week, then you know that this is not a new show, but it is now returning via radio. It used to be a cable talk show, and now we are live on the radio from 5 to 6 today. So we look forward to hearing from you. But before I dive into that and give you all the call-in numbers, I do want to introduce to everybody who we have here in the studio right now. First and foremost, my name is Jacqueline Bryan. I'm one of the injury attorneys over at Perinick and Caulfield, Averill, and Noyes. And to my right, I have
Daniel Havigan here. I'm an associate attorney over at Perinick, Caulfield, Averill, and Noyes, practicing in personal injury, workers' compensation, social security, disability. We kind of do everything over there regarding injuries. So that's me, and directly opposite me is one of the partners of the firm, Matthew Noyes.
Good evening. Yes, this is Matthew Noyes, and I am one of the partners. I've been with the firm now, over 33 years, I want to say. It's been a fun ride. I remember the days of FLA Law on cable TV. We were on 5 nights a week. It was a lot of fun. We took a lot of live calls. They were quite interesting on some of them. And so we encourage you all to call us on the radio too.
Yeah, so let's go ahead and give you that call-in number now. So once we get to chatting, we're going to be talking about various legal issues, of course, more catered towards the personal injury realm. But as we're talking, we do want you to go ahead and call in with your legal questions. The phone number is going to be 727-441-3000. Again, that's 727-441-3000. If you are not in the local area of Pinellas County or Hillsborough, please call us a toll-free at 1-866-826-1340. We are looking forward to your calls tonight. And we also are streaming live. Dan, you want to tell them about where they can find us online?
Sure. You can find us on our Facebook page. Our Facebook username is Perinick, Caulfield, Averill, and Noyes. You just go there right on Facebook. You can see us. We have a little bit of a live stream going here, so you can see what we're doing in the studio right now. We kind of look like a little bit like stick figures right now. We got to loosen up a bit, but
there we go.
But you can ask us your legal questions on there if you're more comfortable with just typing something up. Jacqueline here is going to be able to see those questions and be able to answer those for us.
Yes, and I do see a comment there already from Peggy saying she loves the show. Thank you. We love you too. And hopefully if anybody else joins, they don't want to hear themselves on the radio, you just drop a comment in that Facebook live stream and we will be able to read it right here on the air.
And I just also want to say hi to Peggy. Peggy was one of my prior clients.
Oh, is she?
She's a
Hi,
wonderful
Peggy.
lady. I think she's moved up north. So I'm glad if she did, she's still watching us on Facebook. So
Great.
Thank you, Peggy, for watching us on Facebook.
Wonderful. So as I said, we are based in the Tampa Bay area, our main office being Clearwater. We have offices in St. Pete, Tampa, Newport Richey, but we take cases all over the state of Florida. So no matter where you're listening to us in Florida, we can obviously assist you with these type of matters. So I want to tell you kind of about what the cases are that we take and the kind of topics we're going to be talking about today. So we handle personal injury. So that's a broad spectrum. And I will allow Matt to kind of give us a little bit of a list of what that could mean as far as cases.
Yes, actually, personal injury is quite broad. It deals with any injuries and insurance companies. So it could be car accidents, bicycle accidents, motorcycle accidents, pedestrian accidents. You're going to see a lot of that during spring break, unfortunately. But also slip and falls, workers' comp injuries, And outside of personal injury, but still kind of related to it, is the Social Security disability, because it deals with medical and disability as well.
Right. So those can often be connected. So as we're talking about these issues, I'm going to give you that phone number again. It is 727-441-3000. So first, I don't think we talked about it last Tuesday. So I did want to talk about trip and fall, slip and fall cases, right, Daniel? So is there something that you can tell our listeners as far as an important tip of what they should do if they have a trip and fall or slip and fall accident?
Yes, I know it's difficult in the moment, especially when you have an injury, but you kind of have to put your lawyer hat on right when you get in a trip and fall accident, because you got to think, how can I document this? How can I, one, either take photos of the accident? What did I trip on? Oftentimes we get cases where, the client says that they tripped over a loose brick, but then they can't point to where the accident happened, right? So we'd love to see the actual defect, the actual item, object, et cetera, that the client slipped on or tripped on, if it's wet water, et cetera.
Exactly.
So we want that. If it's a trip and fall in a store, slip and fall in a store, file an incident report, get the manager of the store involved. They will help you out and get that incident report done.
Way too many times they wait too long to then go to the manager and say, "Oh, I fell 2 days ago." Mm-hmm. Well, that security footage has most likely been recorded over, and so they don't have it.
Yeah, exactly. We need to get involved right away. The attorneys over at Parent Caulfield, Illinois, so we can send over a preservation letter in order to keep that video from getting deleted.
Yeah, a lot of times when people slip and fall, the first instinct is like, "Oh shoot, did anyone see that?" And they want to get up really quick because they're embarrassed.
Up, right.
But it's important that if you are hurt, that you take steps to protect your rights and to prevent the next person from falling.
Exactly, and you should also be listening as well after the incident happens, because oftentimes someone who just got injured in a slip and fall at a store, whether a Publix, a convenience store, something like that, you hear employees saying, "Oh shoot, I didn't bring out the wet floor sign. I didn't do this."
Excited utterances.
Exactly. So if there's excited utterance like Jackie says,
of what they're saying.
Note of it.
Absolutely. And nowadays, just about everybody has a cell phone on them. So, whatever you can document, even if something's on your clothing. A lot of people go home, they wash their clothes, but they're not really sure what it was that they fell on. Sometimes your clothes can tell you. There's streaks and stains and things that are on your pants or on your dress. And if you can document that does help, I think, as well. But Matt, what I really wanted to know, because obviously we do workman's comp. So what about if you fall and get hurt at work? Does that change the kind of case you have? Do you just have work comp? Could there be another case out there?
Actually, if you fall at work and it is due to the negligence of the store, then Jackie, you would have two claims. You would have the workers' compensation claim, and then you'd have the third-party liability claim. I did want to talk about third-party liability, or the store being at fault, so to speak. Just because somebody falls, and it's a misnomer, but just because somebody falls doesn't mean that store's automatically responsible.
Exactly.
Some attorneys will say, "Hey, you fell at wherever the store is, come see us." Well, no. You need to prove that the store did something wrong.
There was some negligence,
something unreasonable.
Something that they was not reasonably safe.
Right. And you have to prove that they had notice, that they could have or should have done something.
Actual or constructive notice.
Exactly. Yep. And not, or they didn't do something that they should have done. So,
what I see a lot too, and sometimes when we get the video, sadly, we'll find out that dangerous condition or that slippery thing happened just seconds.
Right.
Seconds before our client fell. And unfortunately, that's not enough notice, for the store or the, property owner. A lot of times it happens so quickly, they didn't have an opportunity to address it.
Exactly. Constructive notice.
Exactly.
They didn't know about it, but they should have known about it through, the time that has elapsed from the point of the mysterious substance being on the ground, whether it be like the employees in the area inspecting and stuff like that. So
yeah, I mean, we as lawyers want to hold the store responsible and accountable for what they do wrong.
Right.
But it would be amiss to say that every time somebody falls, it's the store's fault.
I do think that's a common
It's not.
misconception.
Yeah, it's simply not. And so sometimes people fall and the store couldn't do anything about it. But that's why it's important that when the store could have done something about it, that we hold them accountable and responsible for that.
Sure. Well, do we want to touch up on comparative negligence then while we have that?
I think that's a good idea.
Yeah, that's a good
That sounds like a good law school question. And Daniel's the most recent one out of law school, so we'll let him do it.
Go right ahead.
Well, I wouldn't have if I knew I was going to be put under the microscope here. But no, in premises liability cases or slip and falls, trip and falls, you always get this added element in the case, and that's what's called comparative negligence. That means that the defense can apportion a percentage of fault on our clients, on the plaintiffs in the case, on the person that slipped and fell, saying that, well, you're at fault for the accident too, because you should have seen this wet floor, this slippery substance. Yeah, exactly. So, whether that be 30%, 45% at fault, that depends on the jury, right? But that's always an added defense that we have to take seriously as plaintiff attorneys in a slip and fall case.
Because what happens if the plaintiff, the person injured, is 30%? What does that mean in terms of their damages?
Well, let's say a jury comes back with an award of $100,000, right? But they find the defendant 70% at fault, but the plaintiff 30% at fault. What that does is the court will then reduce the total damages, that being of 100,000, reduce it by 30%. Mm-hmm. So the total damages that would be awarded then to the client, our client, the plaintiff, would be $70,000 because
you're not taking a reduction, an offset, and there may not always, the laws are constantly changing, and so it's very important to understand that concept, because there may be a time where comparative negligence goes away. And if you are more than a certain percentage at fault, you may not have a claim. That used to be that way in the past. Who knows what may happen in the future? So it's very, very important to be aware of, how you have contributed to the accident. What shoes were you wearing? You want to document all those kinds of things, because that's exactly what the insurance company is going to do. They're going to try to point the finger right back at you. And the more your attorney knows, the better we can represent you. So document, take photos, get incident reports done, find out who was there, what employees helped you, and that sort of thing definitely goes a long way in a slip and fall case.
And that was a little bit of an Easter egg there for those listening, because that issue is actually being debated right now in the Florida legislature as for comparative negligence. So if any of you out there that's interested, I take the time, see what's going on up there, and have your own opinion on it. We definitely would advise any citizen in Florida definitely to read up on it.
Be aware of what's happening in the legislature.
Yeah, we're happy to address any of your questions that you have regarding slip and falls or even the law in general.
Yes, so I'm going to give you that call-in number. Obviously, we are here at FLA Law, live on the radio. Our call-in number is 727-441-3000. Again, that's 727-441-3000. And this is FLA Law. The attorneys here in the studio are Matthew Noyes, Jacqueline Bryant, and Daniel Havigan. We are from Parent Caulfield, Averill, Noyes. You've got 3 lawyers here to answer your questions, so please do give us a call.
Yeah, we are the oldest personal injury law firm in Tampa Bay. Guy Pernick started our firm in 1955. And ever since then, we have focused our practice on personal injury. Back then, attorneys did just a little bit about of everything. But Guy Pernick, who used to be an insurance adjuster, said, nah, I'm going to do things different. I'm just going to represent those who get hurt and get taken advantage of by the insurance companies. And so he started our practice, and it's been going strong. And with that focus on being the voice of the injured for
almost
so many years.
68 years, 65 years. And on that note, it looks like we do have a caller on the line. Caller, are you there?
Yes.
Hi, how are you? What's your question?
So I have a question. So I joined a local gym, and I was walking through the gym, and I slipped or tripped. I'm not really quite sure how I fell, but I fell and injured myself. And I was told that, unfortunately, because I had signed paperwork when I joined the gym, that there was a waiver or some sort of exculpatory clause, and so I can't sue the gym. Could you explain that a little bit more for me?
Sure.
Yeah, and I'll take that one, Jacqueline. So in gyms, amusement parks, basically anything fun these days that
Trampoline
you go do,
parks, yeah.
exactly, you're going to get a waiver thrown right in your face saying that if you want to join this, you want to have fun here, you got to sign. And that waiver in Florida, surprisingly, although you may have heard differently, I feel like for some reason there's like a misconception in Florida that waivers aren't enforceable. Mm-hmm. That's wrong. They are 100% enforceable. However, they are strictly construed against the enforceability. So the the courts will look under it with a microscope, making sure that, one, it's clear and unequivocal that the terms are of what you're waiving. So if you see, just I expressly waive in all caps, all bold letters, waive all liability against the gym, against the amusement park, whatever you go to. But what's important is the waivers must be so clear and unequivocal that an ordinary and knowledgeable person will have an idea of what he or she is waving away. Right. Exactly. So it's not a valid defense that if you go, oh, didn't read it.
Sure.
Well, no, judge, the court system, they won't care. Yeah. They won't care unless unless you have a way to say or show that, hey, there's a reason I didn't read that. They hid this from me in some sort of capacity, and there's case law about
really
that.
Tiny print. You didn't actually see it, just a little signature box.
Mm-hmm.
Now I'm a baseball guy, and so I go to a lot of baseball games. And when they used to print out tickets, the waiver or the release was on the back of the ticket. Mm-hmm. It's not on the back of the ticket anymore. But that being said, the waiver on a ticket does not give the stadium or the team free rights of any claims against them. For example, a baseball game. Mm-hmm. If you're there at a baseball game and you get hit by a foul ball or a bat that goes into the stands, you assume that risk, and that waiver will protect you. But if you sit in one of their chairs and their chairs break,
right, that's totally different.
That's totally different. And although the stadium or the team may try to say, hey, you signed the waiver, no. That claim can be made against the stadium for the negligence that they caused.
Yeah, it's got to relate to the actual
the injury,
situation that you're going to sign away, basically, right? So
if you were at the gym and they gave you the small little keypad, you never actually read it, and you're just signing blindly to these, a random keypad and it's just your signature, you don't even know what you're signing, you might still have a claim and can get around that clause.
Right. I had a case a few years ago against Tropicana. Mm-hmm. They used to have that tile, beautiful tile of the water when you walked up to the gates. Well, when it rained, that tile got really slippery. Yeah. And sure enough, someone slipped and fell, and they tried to say that they were protected from it, but we were able to work around that release and hold them responsible. Now that tile's not there anymore.
That's great. And so hopefully that helped you, caller, that you know that you do have some ways around that. We do have another caller calling in. But if you have any questions, you can always reach us at our firm at 727-796-8282. Let's go ahead and take the next call.
Go ahead.
Hi there.
Hi.
Thanks for taking my call.
No problem. Go ahead.
And I already like you, by the way. I'm a baseball girl myself.
Hey, all right. We baseball people have to stick together.
I was just wondering if someone gets a ticket in an accident, are they automatically at fault, or how does that work?
You want to take that, Matt?
I can take that. That's what people often say. They say, "Well, gosh, the other person got the traffic ticket, and so of course, why isn't their insurance company paying for my property damage? Why are their insurance company not paying for my damages?" Well, unfortunately, the evidence of who got the traffic ticket is not admissible in a civil court.
Right.
And it's not admissible because it's based on hearsay testimony. Not to get too legally, because that even puts me to sleep. But really, what it is, the ticket was issued by the police officer who listened to other people tell how the accident happened.
Right.
And so he's not using, or she's not using their firsthand knowledge. And so the fact that someone got a ticket does not automatically make them liable for the damages to the car or to the body.
In the civil case, right?
But it's a pretty good indicator for the insurance adjuster. When
Believe me, we say it all the time.
Yeah.
We say it all the time, yes. And also it's depends on what the ticket's for as well. If it's an improper turn, that's going to be helpful, because it's going to show that the at-fault driver was doing something improperly at the time of the crash. It'd be the lawyer's job to tie that into being the reason why the accident happened.
Exactly. And the good thing about that also is that if you did make some, somewhat incriminating statements to the officer, then that also would not come in later on in your civil case because that's accident report privilege as well. Yeah. So it works both ways.
Yeah, the accident report never gets into it.
Exactly.
Jury never gets to see the accident report.
Yeah. Hopefully that helped answer your call, your question. But if not, you can always give us a call later at our firm at 727-796-8282.
Also with that, even if one of our clients who got hurt got the ticket or got a ticket.
Oh, sure.
That doesn't foreclose them from bringing a claim against the insurance company. They have every right to still investigate, and we would investigate whether or not
the liability.
The liability.
Exactly.
And as Daniel was talking about, it could be comparative negligence, where the at-fault driver may be held partially responsible for the damages that the person caused.
Exactly. Yep. There could be a split. Does that help, caller?
It does. Yes, thank you. And it's also very interesting.
Thank you so much for calling in. We appreciate it.
Enjoy the new baseball season.
Absolutely. You too. Thank you.
Thank you.
Bye-bye.
Bye.
All right. I think we have another call waiting on the line. Caller, can you hear us?
Yes. Hi. Thank you for taking my call.
Absolutely. How are you? Go ahead.
Thank you. So I have a Social Security question.
Okay.
So I was laid off because of too many absences last month. Can I apply for Social Security disability?
So that's a good question. I think there's going to be a lot of factors that come into play when it comes to Social Security disability. And so if you are missing a lot of time from work due to a medical condition, and that medical issue is the reason why you're, having to miss a lot of time from work, and now it's keeping you from being able to sustain what we call substantial gainful activity, and to the point now where you're not able to sustain that type of work productivity, then you may have a claim, especially if you've got the medical evidence to back it up. So if you've been going to doctors and you've been getting medical treatment, and that is the basis for why you're missing work, then I do think it's probably a good idea to reach out to us or Social Security in our Social Security department to kind of review the circumstances behind it. But you do have to be out for a significant amount of time before you can kind of meet that standard, or a doctor has to say that your condition is going to last a year or more. So there's a lot that we could obviously talk to you about and go over with you to see if that's a claim that you can make. I don't know if anybody else wants to add to that.
No, the only thing I would have to add Social Security disability, it all revolves around medical evidence. If you don't have medical evidence, you're likely not going to get approved by the judge or by the social disability examiner, the examiner that's analyzing your case, because these examiners in the first level and right when you send in your initial application for SSD, these are not doctors that are analyzing the medical records here, right? These are examiners, normal people. They want to see diagnosis. They want to see diagnostic exams, hardcore medical evidence that makes it clear there's an injury and it's undisputable.
Right. And the only thing I would add, Jacqueline, you touched base on that, was that, and we get a lot of calls of people that just got laid off because of a disability or unable to work for a month or two.
It's short term, right? It has to be
short. A Social Security disability is not a short-term disability plan. It's a long-term disability plan. And in fact, there's a 5-step process in order to be eligible for Social Security disability. And the second step is, do you have a disability that has kept you out of work for 12 months or will likely keep you out of work for 12 months?
right.
If you can't get past that step, you can't go to
not
step
disabled.
3, 4, and
Right.
5.
Exactly.
And so oftentimes I tell the potential clients that let's see how it goes. Hopefully you can get back to work.
Right.
We always want the people to get back to work if they can. And 6 months, if you're still out of work, let's regroup.
Sure.
Let's see the medical documentation, and let's see if we can beat step 1 and 2 and then go on to 3, 4, and 5.
Well, fortunately, right, you're able to work part-time or a certain amount per month in order to maybe keep a roof over your head while this application's going on, because Social Security disability takes months and months for these examiners to
But you got to be careful with
It's
that,
tricky.
Daniel.
Yeah. It can be a double-edged sword when you do that. Yeah.
Yeah, because you can only earn, I think it's $1,200 or close to
It goes
$1,200
up
a
slightly
month.
every year, but I think it's probably around $1,200 right now, maybe $1,300 at the most.
Yeah.
Right, because
Social
you're trying to
Security
say
was-
something you can't work, but at the same time, you're working
You're
on the back
working,
end here, right?
Yeah.
So
And Social Security said, well, gosh, if you can work if you can earn $1,000 a month, why can't you earn
Yeah.
$1,300? So you don't. That's step 1, substantial gainful activity. And if you can have substantial gainful activity, then you don't even get to step 2.
Right.
Yeah.
So, caller, I'm sure we just gave you an earful. Did that
It's
answer
probably
your
still-
No,
question?
this is great. This is information that, I wanted to hear because, I had so many questions. I'm confused as to how Social Security works. And so
Okay.
No,
thank you for the information. What's that
Absolutely.
number again to your office?
Yes, thank you. It's 727-796-8282, and that's our local office phone number.
Yeah, and we'll deal with Social Security
Thank
disability.
you.
You're welcome. Thank
You're
you for
welcome.
calling, and thank you for listening.
Thank you.
Dealing with Social Security is dealing with the federal government.
Oh, yeah.
And so we all know the hoops and hurdles that you need to jump through with the federal government, whether it's
Red tape.
Social
backlogs.
Security, income, the IRS, or any other kind of governmental entity. It's the challenge that you have, and it's documentation.
Right. So I think right now is probably a good time for us to take a short break. I want to give you the call-in number just one more time. It's 727-441-3000, and we'll be back shortly with FLA Law to answer more of your questions.
This is the Tan Talk Radio Network.
In 1955, the law firm now known as Pernick, Caulfield, Averill, and Noyes made a decision. Instead of taking whatever cases came through their doors, they decided to focus specifically on personal injury. 64 years later, the law firm is one of Clearwater's longest-running personal injury firms. Available 24 hours a day with offices in Clearwater and throughout Tampa Bay, they're ready to put decades of experience to work for you if you or a loved one has been injured in a car accident or injured due to someone's negligence or recklessness. If you feel overwhelmed, uncertain, or unsure about your next steps after being involved in an accident or after a loved one sustained serious injuries due to someone else's negligence, call Pernick, Caulfield, Averill, and Noyes at 727-796-8282 or online at usalaw.com. That's 727-796-8282 or online at usalaw.com. Non-attorney spokesman.
We're back in Dade City. Your adventure begins at the Bay Area Renaissance Festival. 8 stages of exciting and hilarious entertainment. Full contact live armored jousting, mermaids, fairies, pirates, Vikings, and more. Endless shopping at more than 100 different artesian booths. The Bay Area Renaissance Festival. Family fun for all. Weekends, February 19th through April 3rd. Mark your calendars and get your tickets now at BayAreaRenFest.com.
This is the Tan Talk Radio Network.
And we're back with FLA Law live on the radio, your live call-in legal question show. And I do believe we are already waiting on a caller, so we're going to go ahead and take that call now. Caller, are you there? Can you hear us?
Yes, I can.
Hi, how are you? Go ahead with your question.
I'm good. Yeah, my question is, so I've not been able to work for over 10 years. Am I entitled to SSA disability?
That's a great question.
Right.
So I don't know if anybody wants to jump in, or I could take this one.
I'll let you take it. Jack, why don't you start? And then, we lawyers can't keep our mouths shut, so we'll probably interject.
Right?
Yeah.
So if you said you've been out for about 10 years, then that is going to be an issue involving your work credits. So when it comes to the Social Security Administration and applying for disability, it does require that in that 10-year period, you would have had to have earned 20 work credits, I believe it is. Right. And in order for you to have 20 credits, you would have had to have worked at least 5 out of those 10 years in order to qualify under the Title II program, which is SSD, which is a higher benefit. However, if you meet certain income standards, there's a second program under Title 12 that's for SSI that you might qualify for. However, it is very particular in terms of your resources and your wages and your income and assets. So there would be a lot of questions we'd have to inquire into to find out whether you met the first. The second program. But if you've been out for 10 years, then it sounds like, fortunately, you may not have the work credits that you need for the disability program.
Right. It probably won't be Social Security disability, but it could be SSI benefits.
It could be.
And going off of like the income and stuff, they're not only looking at yours, but potentially your spouse's as well to see if you meet the income requirements in order to get that SSI.
That's correct. SSI is more a governmental assistance as opposed to Social Security disability, which is really repayment for what you paid into the system.
Like an insurance policy.
Yeah,
almost,
so
right?
SSI is something that people are entitled to. They must have very limited assets, and they must have a very limited household income, like you were talking about, Daniel, in order to be eligible for SSI.
Right.
But also, they have to still meet the medical requirements.
You still have to have the disability.
So even if you have all that proof, but you don't have the medical documentation that you'd be eligible for SSI benefits, then you would not prevail in the SSI claim. So it always goes back to medical documentation.
And in Social Security land, to know if you might potentially have a disability, it's really easy. Just go on Google on the web and type in what you're suffering from, and then the Blue Book. It's called the Social Security Blue Book. They have basically a step-by-step process of what if you're diagnosed with a certain condition, on whether or not that condition qualifies you as disabled or not.
I don't know. It's really easy though, Daniel, because it's easy for us to say that it should.
Yeah.
But I mean, we have some people that have MS that are able to work.
Right. It depends on the degree.
And they can't work. So it is a good starting point. I agree with you 100%. It's a good place to start. But I don't want anybody to think that just because their condition is on the listing, that it makes them automatically entitled.
We'll certainly argue that, though.
Yeah. Oh, yeah. The difference between SSI and SSD also is really the medical benefits, that you get after you qualify.
Sure.
An SSI, you get Medicaid, but if you qualify for SSD benefits, eventually you'll get Medicare benefits.
Right. So, caller, are you still on line? Does that help answer your question?
Yeah, most definitely. Actually, above and beyond. I appreciate it.
Thank you. That's what happened when you've got 3 lawyers on the phone. So thank you for calling in. We appreciate you.
All right. Thank you.
Thank you very much.
So I think it all kind of intertwines because with
really
work
does.
comp and auto cases, these people can have really severe injuries to the point where they can't work anymore. And so
Exactly.
that's why I think it's great when you have a firm like ours where if you get hurt in an auto accident, you can't work anymore, we can assist with the disability claim.
Yeah, that's exactly how our Social Security disability division started. We were representing all kinds of people that got hurt at work. We were handling the workers' compensation claim, and they couldn't go back to work.
Right.
And so we were referring them out to other Social Security disability attorneys. But it's always better to have the one attorney who knows the person to handle it. And so that's when we started to do our Social Security disability practice as well. And it's been growing and growing for 10 plus years. So.
As long as I've been there.
Yeah, it's probably longer than 10 years, quite honestly. But it's a good service to have. The people with the people that need Social Security disability benefits, are really struggling. I mean, can you imagine not being able to work for at least a year before you qualify, and then you have to go through the whole process.
Right.
Mm-hmm.
And the longest wait time is from the time that you get request a hearing, to the time that you get the hearing date.
Right.
And right now it's in the Tampa Bay area, it's about 18 months from that time. So you wait a year before you are eligible for SSD. You file the application, you wait for that denial. You file the reconsideration, you wait for that denial, and then you file the request for hearing, and then you got to wait.
Another 18
It definitely
months,
tests your patience.
Well, and that's why it kind of drives me a little bit crazy is when people say, somebody's on SSD, they're just milking the system. No way. They had to go through hell in order to get to where they're at, and they'd much rather be working if they could.
Right. And imagine all that they've lost in that time.
Yeah.
And so that I wanted to segue back to something you mentioned, Matt, because a lot of times we do see severe work injuries that also lead to disability. And we touched on it very briefly early on with the trip and fall segment. I would like to go back to work comp.
Sure.
So if we get hurt on the job, a person is hurt. Let's say we go back to the scenario where we're in a grocery store. Let's say I work for Coca-Cola and I'm stocking in the grocery store. And I slip and fall on something there and I get hurt really severely. What are my options in that type of a scenario?
Yeah.
Well, look, it depends on who caused the slip and fall, whether it was a third party or it was just your employer. If it was your employer, unfortunately, the only recourse really is going through work comp, unless there are certain situations where if it's so outrageous, if they knew something was going to happen, the employer, you can potentially get out of work comp land and into civil in general.
Right, I think it has to be pretty much intentional.
It's got to be basically like an intentional tort, right? So, but that it's tough. That rarely happens, and you're in work comp, and you're dealing with the work comp adjusters, the work comp, they're authorized providers, and you're getting your medical treatment that way. Now, if it's a third party who caused the spill, the substance that you tripped and fell on, then you have a third party claim, right? And you can go through civil court and go after them. So.
Right. And under workers' comp, you're limited to whoever the workers' comp carrier sends you to for treatment. That was going to be my
next question.
Mm-hmm.
So what benefits are you entitled to under workers' comp? Because a lot of people are confused about what you are entitled to under the workman's comp system.
Yeah. We've been doing workers' comp for a long time, and one of the most popular question that's asked is, can I see my own doctor? And the answer is no.
Sorry.
You can't. You can't get a second opinion. Workers' comp is purely statutory. And it says you get a doctor selected by workers' comp. And if you don't like that doctor, you can change that doctor one time.
You get that one-time change, and that's it.
For the length of the case, and so you're kind of stuck with the workers' comp doctors. There's some very good workers' comp doctors. There's some very insurance-oriented workers' compensation doctors. And so you got to use that one-time change very carefully, just to use it because, it's a delay in getting the care. That's not usually the way you want to use that one-time change.
Yep.
But I also wanted to bring up a little bit something else, and that is coworkers causing the injury. If you're that Coca-Cola guy and it's your coworker that spilled whatever you slipped on,
right?
Then even if he was clearly negligent, you do not have a right to bring a claim against your coworker.
Right.
Workers' comp is your only avenue, and we see that a lot.
Immunity.
Yeah, we see that a lot in car accidents. We'll have 4 people in a car driving within the course and scope of their employment, driving for work, and their coworker clearly is not paying attention and smashes into the rear of somebody's car, and the people inside their car are injured. They get workers' comp, and that's it.
Yep.
That's a part of the unfairness, I think, of the work comp system.
Yep. Work comp immunity is exactly right. And like we said previously, it basically has to be an intentional tort for you then to go and sue your employer instead of going through the work comp realm of things and getting that authorized provider and going through that system. So
the most important thing is I always say about the workers' comp is people say, well, I got hurt at work and they're not providing me a doctor. They don't have to provide you a doctor unless you ask for it.
That's true.
And workers' comp is not on the hook until you ask for a doctor.
How long should you report an injury at work, Matt?
You know these lawyers. A reasonable time to report the injury at work,
Well, they'll try and get you if you don't report it and give notice to a manager within 30 days, right? So you gotta make sure
the statute says within 30 days, but they also try to say untimely even if it's not within 30 days.
Right. And the lawyer answer is report it right away.
That's exactly right. That's exactly right. And sometimes the supervisor is there at the time of the accident. Fortunately, there's not many good cases in workers' comp that helps the claimant, but there are good cases that say that if the employer was there and has knowledge, then that supervisor, not coworker,
right,
but the supervisor's knowledge is imputed on the carrier. And
exactly.
Right. And this is a question I get a lot from my clients with work comp, and it's I believe it's a common misconception out there with Floridians, and that's pain and suffering in work comp.
Oh yeah.
And unfortunately, there is no such thing.
And that's really important to a lot of injured workers. Is I've been through a lot of pain, a lot of mental anguish, and this has changed my life forever. And they want to be compensated for those damages, but can they, Matt?
No, they cannot. I give this scenario. I used to be. Before I went to law school, I was a waiter at Denny's restaurant. I love that's the best job. Any lawyer who wants to be a lawyer should do is being a waiter, especially if you have to work the graveyard shift. So you get to deal with all kinds of people. But I digress. Really, I give a scenario that if I'm a waiter and I'm walking next to a customer and we both slip on water that's on the floor caused by a faulty equipment, we have the same exact injuries. We're unable to work for a year. We broke our leg. We lost our car because we couldn't make the payments. We weren't able to go on vacations because of our injuries. Me as the waiter gets a workers' comp doctor and 66% of my wages. And that's it.
That's it.
The customer, same injuries, same causation, same everything, gets the medical benefits past and future with the doctors that they choose, past and lost wages at 100%, pain and suffering, mental anguish, loss of enjoyment of life, and all those other damages, intangible damages that rightfully you're entitled to.
Right.
I'm not saying that the customer's not entitled to it. I just think that the employee should be a little better compensated for the injury.
Exactly.
Workers' comp was designed many years ago to be a quid pro quo. system. We give you the benefits. You don't have to prove that the employer was at fault, and we'll give you the benefits. Well, the benefits have decreased, but their
fault is
their fault. The benefits have decreased, but the still not punishment, but the inability to bring a claim against the employer has remained the same. So it's not quid pro quo anymore.
It's not a fair system, but of course, if you find yourself in those type of issues with the work comp injury, you can always reach out to our firm, Pernick, Caulfield, Averill, and Noyes. We're located in Clearwater in the Tampa Bay area. Our local number to our office is 727-796-8282, and we are still on the air for a little bit more with FLA Law. So if you have any questions, we've still got some more show to go. Feel free to give us a call live at 727-441-3000. Again, that's 727-441-3000. We are still here in the studio to take your calls.
Yeah, you got to be careful because we got 3 lawyers in the room, and we get up on our soapbox, and it's hard for us to be quiet. We just see the injustice that our clients go through, and the insurance companies take advantage of people so dramatically. Whether it's the auto accidents or whether it's the workers' comp, and the fight that you have to have for Social Security disability benefits.
Fortunately, we have bad faith still in existence to this day,
for a little
now.
bit.
So.
So obviously it's that time of year, folks. We are in spring break season. I know Pinellas County schools are on spring break. I'm sure many colleges are as well. Is there any tips or advice you have to anybody coming into the area? We are in Clearwater, so the beaches are very popular here. Any advice you'd give to those that are driving on the roads, headed down to the beach, to kind of look out for or be aware of in our area?
Daniel, what do you say?
Well, I mean, if you're an out-of-towner, you need to be aware of who's driving, whether it's the Uber, you're getting an Uber, you're getting a Lyft, anything like that. There's insurance involved when you're in a Lyft, Uber, and they have what's called uninsured motorist coverage. Well, actually, no, they don't anymore.
No.
They have
That's why you need uninsured motorist
bodily injury coverage while there's an active ride going on. If not, then you're stuck with the actual driver's own insurance information.
You mean policy. The person who's visiting from California or another area?
The driver.
That's what I'm saying.
So,
he's down on spring break. You're going to have to try to track him down when he goes back up to wherever they're from and do it.
But it's on the roads. It's a lot different when you're dealing with different insurance policies. And in a premises liability case, you're dealing strictly with usually just the insurance company of that business.
Right.
And in Florida, there's really 3 elements of an auto case you need to be aware of as far as insurance goes, and what that means: PIP, personal injury protection, uninsured motorist coverage, and bodily injury coverage.
Mm-hmm.
And uninsured motorist is the most important. Uninsured. This is the time of the year that you got to be
100%.
You got to be looking at your policy before spring break really gets here, because what happens is that if one of these wonderful spring breakers, we love them. It's great for our economy. But if they cause a crash and they don't have insurance, you're stuck. Unless you have uninsured motorist coverage. Uninsured motorist coverage will stand in the place of the at-fault driver.
Right.
And you be able to be compensated for your medical bills. You got medical bills. They got to be paid. Once the PIP is exhausted, then who's going to pay those bills? Lost wages. They have to be paid.
And what's important with UM too, it follows the person, right? So even if you're in a person's vehicle, and that driver, that owner of the vehicle has no UM on that policy in that car, if you're in that vehicle, you have in the backseat, you're having a beer in the backseat, hanging out.
Which we don't encourage.
We don't condone.
Spoken from the youngest attorney.
But your own UM policy does follow you. So if you do have a vehicle and you have UM coverage, you will be able to get access to that policy.
And even as a pedestrian, let's say you're just crossing the street down on the beach,
right,
and someone is, looking through their playlist on their phone, not paying attention,
enjoying the beautiful sunset.
Right.
I mean, they could be totally totally.
There's a lot of ways to be distracted out on the beach.
Distracted, but and
people walking around in bathing suits. So
they used to have those hot dog. I'm probably dating myself. They used to on Ulmerton Road. They used to have the hot dog vendors on the side of the road that served in bikinis.
Yeah, I've never seen that
on
before.
Ulmerton.
On Ulmerton Road, yes, and that was a long time ago, but they did have them. I am, and they stopped it because they were causing too many car accidents. I thought maybe some billboard attorneys will be putting up their billboard right there, but so it is distraction. So uninsured motorists is so important.
Check your policy today.
Yeah. Also, what people don't understand is that visitors come down and they rent cars.
Mm-hmm.
You would think, well, gosh, they're renting a car, and so there should be plenty of coverage, Hertz or budget or whatever Avis, they should be providing coverage.
Right.
But that's not the case.
Right. And that there's an amendment called the Graves Amendment that actually protects the rental car companies and does not allow them to be sued just by virtue of them owning that vehicle. So sadly, there may be no coverage through the rental car company. We've got a few more minutes here to take your calls. So if you have a burning question and you want to get it in while we're still on the air, again, the number is 727-441-3000. And again, this is FLA Law on the radio. So any other tips for spring breakers?
Let me just go back to the rental car really quick, because people may not appreciate that if you own a vehicle, if you allow someone to drive your vehicle, even though you're not in the car, you're responsible for the driver's
dangerous instrumentality doctrine.
Exactly. So us, lawyers or nurses or homemakers who let their car be driven by a permissive driver are on the hook. But rental car companies who make money selling rentals aren't responsible.
Mm-hmm.
I don't get it.
It shouldn't be that way.
And
that brings us back to our legislature.
And that's national. That's not state. That's a national amendment, which is.
And these are important tips right now, actually, with Friday being St. Patrick's Day, right? There's going to be a lot of stupid people on the roads. And, I hate to say it, but there's going to be accidents as a result of that. So
be aware, check your policy, carry UM. That would probably be my parting word of wisdom, is to check your policy. And if you have questions about your insurance, you're not sure, and you want someone to give you some advice, feel free to give us a call. Our number at the office is 727-796-8282. Again, we do personal injury law. That includes car accidents, slip and falls, workers' compensation, medical malpractice. That's kind of the gambit. But of course, if you want to know more about us and what we do, and you want to check us out online, our website is www.usalaw.com.
And look, if you don't even have a question as far as injury goes, you can still give us a call the next day. We'll do the research and try and find an answer for you.
We've been here long enough. We know all the attorneys in the area, so we can always refer you out to somebody who does know those answers.
Absolutely. Any parting words, Matt, for our audience?
We just appreciate, we appreciate you listening to us. We will be back next week. I think it's be the three of us again next week.
I believe so.
Before we start having guests come in. But thank you for listening.
Thank you. Same time, same place
Everyone
next Tuesday.
Everyone have a happy St. Patrick's Day and see you next week.
Drive safely.
Bye-bye.
WTAN, Clearwater,
FM 106.1,
WDCF, Dade City,
FM 102.3,
WZHR, Zephyrhills,
FM 104.3.
Listen.
You're listening to the Tan Talk Radio Network.